to elections by the people and not selections by the House. But in fact, what we have here is that the House of Representatives selected Bill Bray rather than there being an official election. Because nothing, really counts in a legal sense up until certification of the vote. People will not, in normal times, even take office unless they've actually been certified to be the winner. There are a few, years that will start to roll a little bit on the presumption that somebody is the winner, but those are reversible. But certainly you don't have a formal and official swearing in, which is what the defendants did here. So you have that phrase in the Constitution that elections shall be by the people every 2 years. You have Article 1, Section 4, saying that the times, places, and manners of holding elections for senators and representatives shall be prescribed by each state. And you have equal protection, which comes in through the due process and equal protection clauses of the 14th Amendment, which is Bush versus Gore and things like that. So when you look at the Constitution as a whole, it is clear that after the June 6th election, they're coming in and they're trying to change the power relations between the states and the feds through the swearing in. But the only way that they can do so is by invading the Article 1, Section 4 state power over the time, place, and manner of elections. The Constitution is set up to work as a harmonious whole. You can't have one part of the Constitution violating the other part of the Constitution. That leads to another reason why the defendant's arguments have to be dead wrong in terms of the court being powerless and the court being jurisdictionless, powerless to protect its own voters, the voters of San Diego County and of the 50th Congressional District. And that is because if they are correct that this swearing in triggers this exclusive jurisdiction, then each branch of the government, and specifically the legislative branch, the House and the Senate, could do absolutely anything that they want to do, and there would be absolutely no remedy. So really what their arguments amount to is they are interpreting Article 1, Section 5 to create a species of absolute power. And as the saying goes, absolute power corrupts absolutely. I like to say that secret vote counting power, or the kind of vote counting that exists in electronic elections, is a form of absolute power that kind of sneaks up on the American people without them even knowing it. So it's an even more insidious form of absolute power, because if you happen to be in the room or you happen to control the program where secret vote counting is taking place, you certainly have a form of absolute power.
Great. Recording.
Okay, so at the beginning I said, remember, the federal government in a free country was designed to be a government of limited powers, and the courts were designed, at least since Marbury versus Madison, so held, to do judicial review. So, but what the courts can do judicial review of is the constitutional limits, because see, if the federal government is supposed to have limits on it, how are we going to stop the House of Representatives from exceeding those limits? And the way that you do that is you ask the court, say, hey, I think they just acted unconstitutionally. All right, and this is what we ask the court to do with respect to the early swearing in. So that, I think, distinguishes it, among other things, distinguishes it from the prior precedents, because we're saying that this swearing in was, extra constitutional, it was abusive, it was too early, and it was basically without force and effect. On the contrary, or in the alternative, you're allowed to argue opposite things at the same time. He said if it was effective, then in the course of dismissing the case, the court would have to say that the certification of the election was void. It was invalid. We didn't have an election. See, because nobody had power to do anything after Bill Bray was sworn in. So, if that's the way they want to interpret it, then then they sort in a sense agree with us that the election was invalid. They just get there through a different reasoning process. They might try to argue that there was some. They would have to resort to all kinds of legal fictions to say, well, he was sworn in, but there was some kind of residual jurisdiction that kind of hung around until certification. The letter from Paul Vinovich that was submitted to the court from the House, claiming that the House of Representatives had conclusively determined that Bill Bray was the winner. Again, suggesting that they are the deciders here. They are the selectors, and they've seen quite enough of this election business. Thank you very much. And they've decided conclusively that Bill Bray was the winner. But again, we've got to have judicial review of constitutional stuff. The courts can't necessarily rule upon things that are not constitutional. But if there are to be any meaningful limitations on the powers of other branches at all, there has to be judicial review at the constitutional limits, because those are the limits to which they cannot go beyond without violating the very Constitution. So here again, if we were to accept the defendant's arguments, again, interestingly enough, they are arguments for absolute power. We can do absolutely anything that we want to do. And that's not what judicial review of the constitutionality is all about. So, and if it's not, there's also this notion of separation of powers, which is what they try to say. Separation of powers, you can't interfere in a co-equal branches activities. But if you think about American history, you can think of times where, yes, indeed, the courts have opined about the constitutionality of the executive's actions, Nixon's, Clinton's, these kinds of things. The constitutional limits have certainly been before the courts. So there's not really any serious question that the courts can, through their judicial review powers, pass upon the questions of the constitutionality of the actions of the legislature. So that being said, that is pretty much the general parameters of the Article 1, Section 5 arguments that they've set out. They've cited a case called McGee. McGee happens to rely upon some cases that state that this exclusive power exists even to congressional primaries, which is no longer the view accepted even by the House of Representatives. There's a resolution called House Resolution 317 in the year 2003. It was a congressional contest coming from the state of Hawaii, and the House of Representatives unanimously dismissed it because they said it had to do with a primary. We don't have any jurisdiction whatsoever regarding congressional primaries. So that's what they said as recently as 2003. But that didn't stop them from, in Nevada, from the judge saying, I have no jurisdiction here in this Republican congressional primary in Nevada because of Article 1, Section 5, citing to some older cases and not apparently citing to the House of Representatives' own view of its power in 2003. Based on the House resolution in 2003, it's clear that the Article 1, Section 5 power does not reach all of federal elections because it admittedly does not reach the primaries. So we've got a line there, somewhere between the primary and the general, and now we're just debating where is that line exactly going to rest. Does it include absolutely everything about the general election? Because if the Article 1, Section 5 power does cover everything, then, could they swear in prior to the election? Well, if the answer to that is no. Could they swear in 1 minute after the election starts? Well, I don't think so. And they swear in during the lunch hour, when they sort of, get some early sense of maybe how people are voting and swear somebody in during the lunch hour on election day. Well, I don't think so. So where is the line going to be? Well, there really isn't any line, any logical, really well-placed place for that line other than certification. That's what certification is designed to be, is the line. It's not only the line for Article 1, Section 5 power, but it's also the line for that's the point at which you can request recounts and at which you can file election contests. All the legal events are keyed off of certification. So it's not just a formalistic affair, but that's how, it's kind of like the entire election orbits around the certification date in terms of calculating deadlines and stuff like that. There was in the court's ruling, courts usually, in situations like this, they sort of suspect that they're quite likely to go up on appeal, and so sometimes they give a secondary basis for their ruling. In this case, the court said, kind of looked at I don't know if he actually looked at the affidavits of Gail Jacobson and Lillian Ritt, but the court ended up saying something to the effect that affidavits seemed to be insufficient, cited some old cases, and suggested, among other things, that they weren't based enough on personal knowledge. Citing some old cases. The interesting thing about the personal knowledge requirement is that I had clearly argued, and I know this is one of the 3 or 4 places where the judge seemed most engaged and interested. I clearly argued that the electronic vote counting was secret vote counting and that no human being had ever seen or had personal knowledge of the electronic votes being sent through the scanner. I mean, they're going through too fast. No human being has ever counted these. We're just basically taking the secret software's word for what the results of the election are. There probably is a little bit of hand counting, maybe with regard to some provisional ballots. So for the court to fault us for not having enough personal knowledge in the affidavits literally means that the court has set out an impossible standard, because it is not possible for citizens to have personal knowledge about how the votes were counted properly or improperly when the count is being done by trade secret proprietary software. It's being done on the computer level, on the invisible level. No human being, not even a government voting official, has ever seen the counting or done it themselves. Thus, a hand recount becomes especially important. So, again, when the court says, there's inadequate personal knowledge here, it sets out an impossible standard, not only because nobody has personal knowledge, nobody can have personal knowledge until there's a hand count, but also on another level, even if we had a dozen Diebold whistleblowers that spoke to Gail and Lillian, and which then became part of their affidavits, that still would not be part of Gail or Lillian's personal knowledge. That would be hearsay knowledge, things that they just heard along the way. So it's doubly impossible to base that on personal knowledge. The only thing you can do is base your allegations on what's called information and belief, which was done, and which the court suggested was not going to be sufficient. So my interpretation of that is not that the court is especially brutally unfair and impossible to the plaintiff, or not that the court is especially unaware of what he's saying, but I think the court, in finding that it didn't have jurisdiction, set this issue up interestingly, so that on appeal we can argue about secret vote counting and how that impacts the statutory structure and creates difficult and impossible burdens for any member of the public, now that the technology has changed our election system so radically as to take our vote counting away from being visible and supervisable by the public into something that is invisible and non-supervisable by the public. To put a big overarching picture on it, the elections process from beginning to end, in the beginning you have the secret vote counting, in the end you have all the complications and the manual audits and all that kind of stuff in the voting. But at the end, according to the defendants, you have a get out of jail free card. and that is that they can just swear somebody in if they sense an election contest coming up, and thereby terminate the authority of anybody but the House of Representatives to look in to the question of who won and lost. Possibly there might be some debatable issue whether there's any criminal prosecutorial authority for any crimes that were committed, but it would not affect who sits in the Congress, who holds the levers of power, and who gets the vote in Congress, because according to their view, that is strictly within the Article 1, Section 5 power. So the problem is that you have, if this continues on to be used, not just here, but in the Nevada primary, but possibly in Texas, and the construction of the defendants is accepted, which is that the only person that can challenge it is the candidate, and the only place the so-called losing candidate can challenge would be in the House of Representatives itself under the FCEA, or the Federal Contested Elections Act. So basically, if the House of Representatives wants to abuse this power, set it up as an absolute power, go in and select their own winner, the only remedy is for the losing candidate to appeal to their lords, I guess, their masters in the House of Representatives, and ask them to change their mind about a decision that they just made. You know, so if you assume that the decision made was abusive or illegal or quasi-criminal or criminal, it's extremely unlikely that they're going to change their mind. It's kind of like if somebody, you know, steals something from a bank or whatever, it's like asking them, could you please put that back? I mean, they're not going to do it. They've already made the decision to commit that particular act. It's not something that they're going to be inclined to review the fairness and propriety of in any kind of a fair type of manner. So the Federal Contested Elections Act is argued by the defendants to be the remedy, but when it involves the abuse of a constitutional power, you know, the premature swearing in, it's not a remedy at all. It's futile. It would never result in anything. There's another reason why it's futile, specifically with this short-term special election, because assuming the defendants are willing to appeal, and we'd have every reason to believe that they're going to appeal this, one or more levels, even if they lost at the trial level. As a practical matter, you'll never get an order or a result or a recount or anything under any view of the law in time to matter. Basically, the November election is going to run out the clock. So, in one sense, if you want to look at it this way, with a short-term special election, it's free for the stealing, because the only thing that you can do if an election is stolen, if there's fraud or whatever, is do a recount or an election contest. If that election contest takes too long, then as a practical matter, there is no remedy. So even if the House of Representatives was actually fairly inclined to change their mind, it, as a practical matter, won't matter, because they'll just run out the clock. So that's the Federal Contested Elections Act has been used numerous times over the years, but by candidates. But there have also been parallel state election contests, and there have been state court cases around the country that you can in fact have a state-based election contest. The advantage of the state-based election contest is that states typically allow voters or electors to have an election contest, whereas the Congressional Federal Contested Elections Act does not allow any kind of voter standing. And that has also taken place over the years, but there are authorities that are all over the map, so that creates some ambiguity. The correct view, in my view, would be the Democratic view, the pro-elections view, the view that recognizes that all legitimate power comes from we the people, the view that recognizes that it is the people in the states that started this whole federal constitution, and that is to understand that there are certain powers that are not waivable by the people. They're not anything that can be delegated by the people. There are powers that stay with we the people ourselves. And the key one is the right to supervise, observe, and contest our own elections. Because if the power is coming from us in elections, that sort of makes the people the boss or in control of things until that power is transferred to the representatives and senators. But in order to make sure that that transfer is legitimate, the people have to be able to watch the vote counting. The government can't do it. They can't do it by asking somebody else in the government to do it. They can't do it by picking their favorite corporation to help them or whatever, because the government gets all of its power and all of its money through elections. So it's kind of like writing your own paycheck. It's kind of like determining the scope of your own power. That is not the kind of checks and balances that our country was founded upon. Again, that's this idea that the only limit on your own power is yourself is the argument for absolutism, or the argument for tyranny. So there are structural reasons, in addition to the various places in the Constitution, why the kinds of things that they're arguing for can't be true, and why the kinds of things that we are arguing for must be true if the United States of America and our Constitution are to remain what we were taught they were in the first place. That's it.